Home means more than just four walls. It means a meal, a bed, a community that cares. Across Wisconsin, realtors come together to make a real difference, feeding families, building homes, and lending a hand when it matters most.
Good morning, everyone. Welcome to Legal Landscape. I am Wendy Huang. I'm an attorney here at the WRA and Director of Curriculum Development. And today we're going to be talking about the FinCEN reporting requirements. And I'm here with Jennifer Lindsley. She is a legal counsel here at the WRA and Director of Licensing and Legal Services. Thanks for coming on, Jennifer.
Of course.
All right. So we're going to be talking about FinCEN. So can you tell us, what is FinCEN?
So FinCEN stands for the Financial Crimes Enforcement Network, and it's a part of the United States Department of Treasury. And their whole goal is to look out for financial crimes, specifically money laundering. And this new FinCEN rule is all about trying to track and eliminate money laundering in the sale of residential real estate. So that's what FinCEN is. And they do other enforcement actions, but all we're going to talk about today is the money laundering aspect of it.
Makes sense. So what is this new rule about? So obviously money laundering, something with money laundering, real estate, right?
So this FinCEN rule, they're trying to reduce or eliminate the use of residential transactions as a way to launder money. And in terms of how they do it, I guess there's, criminally obtained money, and then they buy a property, and then they sell it as a way to distance that money from the criminal activity that generated it. So they're looking at residential property. What this rule is focused on is if it's a residential property and it's an all-cash transaction, which I'm going to talk more about what that means in a minute, and it was purchased by an entity. So all three things need to be true for the FinCEN reporting rule to kick in. Residential property, which I'll talk more about that in a minute, all cash, and then it has to be purchased by an entity. In terms of which transactions are covered, like I said, all three of those things need to be true. Residential property is not just, your single family home. It also includes condos. And there's two aspects that we might not be thinking about as it relates to residential real estate. One is if it's mixed use. So, think any downtown Main Street in Wisconsin, and there's a bar on the main street, and then above it, there's two apartments. That counts as residential. Even beyond that, if it's vacant land on which a residence will be built, that also counts as residential. So in terms of framing this for what these reportable transactions are, it's not just like a single family house. It goes a little bit beyond that. In terms of non-finance transactions, what they're looking at, so if I go to buy a property and I am going to borrow money from a bank, a traditional bank, credit union, whatever, those institutions have anti-money laundering rules where if there's something suspicious about my transaction, they would have to report it to FinCEN. So if I'm not going through a traditional lender and I'm not under those money laundering rules, what this rule is trying to get at is me moving money outside of those other existing rules. So when I say all cash transaction, it could be I'm literally buying it with all cash. It could be that it's privately financed. Maybe I have a charitable organization that's going to finance the transaction on my behalf. That counts as all cash. Or if a family member is going to finance the transaction on my behalf, that also counts as an all-cash transaction. Or if I'm going to like a private, what they call a hard money lender, again, outside of the traditional banking system, that counts as an all-cash transaction. And the one I think for us in Wisconsin that is going to maybe catch some of these transactions, it's also seller financing that would be considered an all-cash transaction. So if you think about, you've got the family farm that's been in the family for, however many years, generations, and the parents are ready to move on, and they're going to sell it to an adult child. And that adult child they're going to land contract finance it. So the adult child is going to pay them off over time. That counts as an all-cash transaction too. The third part that has to be true is we've got residential, all cash, and then the buyer's an entity. And when I say the buyer's an entity, I mean not an individual like Jennifer or Wendy. but like an LLC or a trust or a corporation. So going back to that family farm scenario, let's say you've got the farm that's been in the family for generations. They're going to land contract, sell it to their adult child. The adult child, for some reason, doesn't want to buy it in their own name. So they've set up a trust or an LLC, which is not in any way unusual. And their LLC is actually going to buy the property over time by making those land contract payments. That transaction would be considered FinCEN reportable. Even though there's nothing nefarious going on, there's no money laundering going on, but even that totally legal transaction would have to be reported under these FinCEN rules.
Makes sense. So seller financing, that's going to be a big one.
Yep.
Obviously, we talked about all cash. So again, just to reiterate, if it's an entity, the buyer's an entity, and it's going to be all cash, whether that's seller financing or a private lender or someone just giving them the money to pay for it, and residential.
Right.
And that includes even if it's a hair salon and there's a residential unit above it.
Yes, or vacant land that's going to be built on. And one more thing before we move on from this topic. These reporting requirements are not new. There's been what's called geographic targeting orders in place for a while, and these geographic targeting orders were specific to certain locations and price points. So big cities, big dollar amounts, right? And historically, like Miami, San Diego, bigger cities where you might expect maybe somebody's trying to launder money,
Sure.
and not in like rural Wisconsin where somebody's just trying to sell their farm to their adult child. These geographic targeting orders, these are still in place, but this FinCEN rule is going to take what those requirements were and make it nationwide. So it's no longer going to be restricted to certain areas, and it's no longer going to be attached to a price point. So going back to that family farm, let's say they're going to sell it to their adult child at a bargain because they're just trying to get out of the farming business. They're not trying to make a profit. And I don't know, they sell the farm for $100,000. That's reportable, even though it's not big money. It used to be, the geographic targeting orders, it used to be $300,000 was the threshold. It had to be over $300,000. Baltimore was always carved out, where it was only $50,000 that would trigger that reporting requirement. I have to think somebody watched The Wire at some point and was like, Baltimore, they're always doing the money laundering. I've seen The Wire, Baltimore, $50,000, right? So they've always been carved out at this lower threshold. That's all going to be replaced by these rules. So it's going to be nationwide, no dollar amount. If somebody buys property for $1 and they're an entity and they pay cash $1, that's going to be a reportable transaction.
Sure. So it could be nowhere, Kentucky.
Right.
And it could be for $60,000, and
Yep.
it still would be reportable if buyer is entity, residential, and it's privately or all
right.
cash.
It's outside of the traditional lending. Right. Exactly. Yeah.
Interesting. So who does all this reporting?
That's a great question. It's not the real estate licensee, so good news for all of you out there. It's typically, because of the way we close transactions in Wisconsin, it's typically going to be the title person, the person who's closing the transaction at the title insurance company that will be doing the reporting. And there's been all sorts of research and data. I don't think we know exactly yet how much time that will take and what additional costs that will add to the transaction. But the reporting person is going to be, an escrow agent, a title person. It's not real estate agents, but I do want to mention, as a real estate agent, what a real estate agent can help people do is get ready for this if they know it's coming, help them start looking for the documents that they need. But again, real estate agents, the role that they play is going to be about education. They don't have to actually do this reporting to FinCEN. That is unfortunately for the title industry going to fall largely on them, or attorneys if they close these transactions.
So what if the title company says, hey, agent, you need to be doing this?
We are strongly telling agents not to be collecting this information, and for a couple reasons. One, it's not your job. Two, there's so much risk involved. If an agent, because I'm going to talk in a minute about what data they want from these people, but if it's going from buyers' hands to agents' hands, then to title companies' hands, that's a whole extra step in there where there could be a breach, a data breach of some kind, or somebody transposes a number, or there's an error that happens. So what we want is the consumers to be giving this information directly to the reporting person, not the agent. The agent is not going to be the go-between in terms of creating this information to the person who needs it for the report.
Makes sense. So you kind of mentioned the sensitive nature of some of this information. So what information will these parties have to be giving?
I'm going to talk first about what the seller has to provide because to me this feels a little counterintuitive. It's like I'm the seller. I'm not the buyer. I'm not the one who's using cash. I'm not the one who's an entity. What did I do wrong? Why do I have to report all this information? It's because they're just trying to trace the money and figure out who's the seller. Do they have any part in this money laundering that's going on? Are they in any way involved? So seller, if it's an individual seller, name, date of birth, address, social security number. So that social security number, of course, is what we're worried about in terms of that skipping out of the security network somehow, which is why we don't want agents doing that. If the trust is a seller, name, date the trust was executed, the trust ID number, names and addresses of the trustees of the trust, and then if it's an LLC, name, trade name, address, taxpayer ID. That's really private information. For buyers, when the buyer's an entity, if the buyer's an individual, we don't care, right? If the buyer's just buying it in their own name, we don't care because then FinCEN reporting doesn't kick in. If the buyer's an entity, though, if it's a trust, I'm going to read these so you can gather the amount of data. The name, the date the trust was executed, the IRS trust ID number, the names, dates, birthdays, or dates of birth, addresses, social security numbers of the beneficial owners of the trust. So it's the trust information, but all of the people behind the trust. You could have minors that are beneficiaries of the trust, and it's going to have to be their data that will have to be provided to the closing agent, or they can't close this transaction. If it's an entity buyer, so like that LLC where it was they're going to buy the family farm from their parents, name, trade name, address, taxpayer ID, which is like the social security number for the LLC, the names, dates of birth, addresses, and the social security numbers of the beneficial owners of the entity. So if you and I were to create an LLC, that's our LLC, right? That's going to be the thing that's the buyer. But you and I, as the members of that LLC, would still have to provide all of that personal information to the reporting person who's going to report it to FinCEN, which is why, when the FinCEN rule first, they were first talking about it, and we're going to talk about the implementation date in just a second, but we were working with the title industry to figure out how can we work together to make sure that agents are prepared and title agents are, the title agents are prepared to be able to close these transactions. And we both agreed that real estate licensees should not be the conduit for this information. The best thing that agents can do is educate people. And I'm going to talk more in a little bit about some of the educational resources we have that agents can use to say, hey, parties, you might need to go to the lawyer who drafted your trust to get all of this information. Or you might need to pull up your operating agreement that you have with your LLC to figure out who's got the ability to buy and then who are the people behind that LLC and what their information is that has to be reported.
Sure. So this is a lot of information, and
Yeah.
this is a big change. So when is this going to be happening?
Okay, originally this was supposed to go into effect December 1st, 2025. So we at the WRA were doing our due diligence and trying to get all these education materials out there. We spoke about it at our convention in October. We had a magazine article about it that went out in October. We had a lovely little legal update that went out in September of 2025. And then the day we were at our convention getting ready to talk about FinCEN, the Department of Treasury announced on September 30th that they were bumping the implementation date out till March 1st of 2026. So we were saying, all that stuff we just told you, sorry, that's not right anymore. The date is now March 1st, 2026. However, we decided to keep course with this legal update today just to keep it on everyone's radar. And our plan here is to re-release those materials that we released in the fall, like the legal update, like the magazine article. Maybe we'll promote this again as we get closer to that March 1st implementation deadline. So it got bumped out. So you'll be hearing about this again as we move forward.
I mean, I feel like the earlier the better to find out information, right?
Yeah.
All right. So are there any legal challenges to this FinCEN rule?
Right. That's a whole other question that we're going to be watching. There are a number of court cases that have been filed against this reporting requirement. There's a couple in Florida. I think there's a couple in Texas. So we're all operating right now as if March 1st is going to be the deadline. But stay tuned, because if these legal challenges are successful, we might be looking at a different form of this rule. We're just operating off the information we have right now. The legal challenges are based in two pretty interesting, I think, constitutional questions about this. One is a freedom of speech. So the First Amendment, freedom of speech. The freedom of speech says that you also can't be compelled to speak. And so one of the arguments challenging this rule is that they're compelling people to give information to the government. And that in itself is a violation of the freedom of speech. So that's one of the constitutional arguments that's being made to challenge this. The other one that might make a little more sense is the Fourth Amendment, which is your right to be free from unreasonable search and seizures. They're saying that if we have this LLC and we're buying property and we're not financing it, and we have to turn over all of this information without a warrant, without a judge telling us we have to do so, that's an unreasonable search of our information and seizure of our information. And the reason people are making that argument is because if, Wendy and Jennifer's LLC is buying this property and we're not going to finance it, it's going to be cash, and we have to turn over all this data. We haven't done anything wrong. We're not money laundering. I'm not. I don't know about maybe Wendy is, but I'm not. So, but we still have to turn over all of this data. All of that data goes into a federal database that's accessible by state and federal law enforcement entities, not just now, but in the future. So it's just this whole collection of personal information, even though we're not doing anything illegal. So that's the challenge to it. So just, like I said, pay attention. We'll definitely update you if there's some additional delay or modification of this rule. But those are the big legal challenges to it right now.
Interesting. So just to reiterate, what is the agent's role? So if a buyer or seller is like, hey, agent, I kind of heard about this on the news, or you gave me this, disclosure of this information, how do I find this information? What do I do?
So one of the things that we've done, and we did a little bit of promotion about it, but then the rule got delayed, so we kind of were quiet about it, is there's a FinCEN disclosure report that's available in the WRA Forms library and also Zip Forms, and it alerts people to, again, if it's all cash, buyer's an entity, and it's residential, that there's going to be these reporting requirements. So an agent can have that form available and give it out if it's possible. If you think maybe this is a reportable transaction, there's no harm in providing it to the parties. It doesn't do any damage if you provide it to the parties in a non-reportable transaction. And if the buyer's like, yeah, I am going to buy it with my trust, or I'm going to buy it with my LLC, but I created this LLC 10 years ago, and I don't know where the operating agreement is, and I don't know the social security number of the other members of the LLC, the agent can't be the one that's finding that information. What the buyer needs to do is start doing some homework and some research to try to locate that information, figure out where it is, so that they can report it to the title company. What we're also recommending people do is if there's any questions, if the buyer's like, do I have to report my minor beneficiary of the trust, their social security number, we're going to have the agent direct them to the reporting person so that they are getting the most accurate assessment of the information that they'll have to provide. It's okay to say, this is not my space. I want you to go talk to the title company about this so that your transaction can close. Because if they don't have the data that they need, they're not going to close that transaction. And if buyers and sellers want this to close, they're going to have to go digging for that information if it's not readily accessible. So that form is available. Encourage parties, again, to talk to the title company.
Sure. So what are the penalties for noncompliance? What if a buyer's like, I really don't want to do this. Why do you need this?
Which you might find, and I think that that's a concern that the title industry is having too, is that you have a person who just will not comply and provide that information. The consequence is the title company is not going to close that transaction. If they do, and they don't report the information that they're required to report under FinCEN, there's civil and criminal penalties that are available. They could be fined. There's criminal penalties. There's potentially could be jail time that's associated with this. So you're not going to find a closing agent who's willing to go ahead and close this transaction. So what we want to do is help them. So we want to alert buyers and sellers early on about, you might have to go digging for this homework. Here's this FinCEN disclosure that's going to tell you what you need to go dig up and provide it to the title company. One thing I skipped over earlier that I meant to mention, not only does the buyer have to provide social security number, dates of birth, addresses, all of these types of things, they also have to report how much they paid for the property and where they got the money from. So that's going to, again, you can see how that would be the goal of anti-money laundering, is to find out what that source of the money is.
For sure. And I can see how a buyer would be a little bit resistant and say, why should you know where
Right.
I'm getting this money, right? Okay. So does this rule apply to purely commercial? So what if it's just a business building? There are only, let's say it's like an outlet mall, only businesses, no dwelling units.
Like if it's a straight up warehouse or something like that, there's no dwelling units. It doesn't apply yet. But I've heard a number of people that are in the know that have, worked with the Department of Treasury or FinCEN more extensively than I have, there's definitely predictions that it could be expanded to commercial in the future. And it's almost, if you're thinking about trying to launder large amounts of money, like a commercial building might be an opportunity for somebody to do that. So right now, it's purely residential, but stay tuned. It's possible that they could expand it to commercial.
Sure. Okay, so what are the main takeaways for agents?
All right, main takeaways are what you can do to help the parties get ready is use that FinCEN disclosure. Tell them to get in touch with the closing agent if they have any questions about, I have this data about my trust, is that enough? Or I have this information about my LLC and its members, is that enough? Because the title company is going to be able to tell them, no, you need more information, or you need to go find additional pieces of information. The effective date, March 1st, 2026, but stay tuned. It will definitely let you know if that gets pushed out. And like I said before, the scope, it's nationwide. There's no minimum price. It's residential. It's vacant land on which they're going to build a residence. And there's no institutional financing. A reminder, that could be seller financing. And I don't know if Wisconsin's unique, but we do see a fair amount of seller financing in the state by way of land contracts, whether that's, again, I'll use the family farm for an example, but those would be reportable transactions under this FinCEN rule. And then the responsibility, of course, is with the actual closing agent that's going to do this reporting.
Okay. All right, so I'm just going to check the chat. If you have any questions for Jennifer about FinCEN, feel free to drop it in the chat. Let me just take a look here. Nothing right now, but I did have a question. So does it matter if, let's say that I have my broker's license and I personally own property, but I decide, hey, I now want to transfer this to my LLC because I don't want it personally attached to my individual name. Do I need to still do that if it's my entity?
That's a good question. I'm going to have to do a little more digging into that to find out, because there are a few exceptions, but just purely based on the facts, that would be a reportable transaction. There are some exceptions as it relates to transferring property from an individual to a trust. I'm going to have to double check on the LLC to see if that's an exception.
Sure.
But that's something we can publish in future.
For sure.
Put it out there in a hot tip or something. So.
Yeah. All right. Any other questions from the chat? I'm just going to take a look here.
I wanted to mention, too, we were talking about the penalties that are available. Real estate licensees, this rule, you're not the reporting person, so those penalties, those criminal and civil penalties that I was talking about, that's not for real estate licensees. That is for the reporting person, which is not you. So that's good to know. Right?
Sure. Yeah. So that would be either title company, attorney, whoever's actually
doing the closing.
Doing the closing. And then obviously the potential repercussions for the parties is if they don't do that, they won't have a successful transaction.
Right, which that would affect you, because where do you get paid, right? Out of the closing proceeds. So that's something, again, when we knew it was coming, we got together with the title industry and worked very close, in Wisconsin, and worked with the leaders in the title industry about how can we help. And we decided the biggest way that we can help is have agents get the conversation started by giving that disclosure, saying, this might be a reportable transaction. Here are the documents that you'll have to provide to the title company. I think the last time I looked, the report that FinCEN came up with for the closing agents to complete to report the transaction, I think there was 111 fields that they had to fill in this report. So it's not a small amount of data. And one other thing that we kind of just don't know yet is, what is the cost going to be to the consumer? Because there's going to be some additional expense. It's going to take some time for the title company to do this. What is that going to look like in terms of closing costs? We just don't know yet in terms of what this is going to look like. When I say the implementation date is March 1st, 2026, so any transactions closing on or after that date will be reportable, which means we might want to start thinking about FinCEN disclosure in advance of March 1st, because you could have a transaction where there's an accepted offer the first week of February, but they're not going to, or maybe even earlier than that, like maybe mid-January, and they're not going to close until early March, right? Even though that transaction started before the reporting date, that still would be a reportable transaction if it's residential, all cash, and the buyer is an entity or a trust, not an individual. So, like I said, when I say we're going to re-roll out our educational campaign, we're not going to wait for March to do that. We'll start it earlier because it will be those transactions in early 2026 that might be affected by those reporting requirements that go into effect in March of 2026.
Sure. So the earlier the better.
Mm-hmm.
So when should an agent try to introduce these disclosures in a transaction?
I would say early on when you're listing or when you're meeting with the buyer to write the offer, certainly when the buyer's writing the offer, you're going to be clued in of like, oh, they signed it as an entity or a trust. They didn't check the box for the financing commitment contingency, or they are using the land contract rider. Those are all clues that you're like, this might be a reportable transaction. I'm going to give that FinCEN disclosure then to the seller and the buyer. Maybe the listing is too early. Maybe it's when the offer is written, because then you're going to have the clues of these three things. This might be reportable. Here you go, fellas. You got to go do some homework and dig up these numbers.
Sure. All right. We only have a couple minutes. Nothing in the chat.
We do have a question. The first question here
Oh.
is, does this apply to quitclaim deeds too?
Would it apply to quitclaim deeds too? It could. Yeah, it could. The deed is sort of irrelevant, actually, to be honest with you. The deed is just how we're transferring ownership, and that's not part of FinCEN. So let's talk about that family farm, for example. Parents are ready to retire. They're going to sell the property to their adult child on a land contract. And it's a very generous land contract where they say, pay us X amount of dollars for 2 years, and when it's all said and done, we'll just quitclaim the farm to you. The fact that it's a quitclaim deed instead of a warranty deed doesn't matter. If it's residential, non-financed, and the buyer's an entity, then yes, it would be reportable. So the type of deed, whether it's a trustee's deed or a personal rep's deed, that doesn't matter. But that's a great question, right? A quitclaim deed doesn't get them out of this reporting requirement. So the type of deed doesn't matter.
Okay, that makes sense. Any other questions from anyone?
We have another question here that says, if the buyer is an individual and the seller is a trust, LLC, or corporation or estate, does it apply?
Great question. If the buyer is an individual and the seller is an LLC, trust, corporation, or estate, does this matter? It does not at all. It doesn't matter what form the seller is. What this rule is looking at is what form the buyer is. So if the buyer's buying the property in their own name, none of this matters, right? That's a great question, though. So the form of the seller doesn't influence the discussion.
Okay.
It's all about the buyer.
So seller could be an entity, seller could be an individual. But if the buyer is an entity and it meets obviously residential, non-financed, then it'll trigger.
Yes. And I'm going to say one more thing about the financing, because I keep saying non-financing, and I just want to reiterate, what I mean is we're not going through a traditional lender. It could be the church is buying it. It could be your parents are buying it. It could be that you're getting money from an investor, like a hard money investor. It could be that it's seller finance. All of those would still be reportable. It's just we're not using the traditional bank system.
Right. Who have to meet those anti-money laundering
rules.
Right.
Yes,
right.
indeed.
All right. All right. So it is now about to be 9:30. Thanks for joining us, and thanks for joining me, Jennifer.
Thanks for having me.
All right. This was your Legal Landscape. Take care, everyone.